Yes.
It come up for hearing otherwise. Can it be taken up after tomorrow?
Why?
No.
What
Today,
is the matter about?
let it be taken up at 2.
Yes, sir. In the first step, second I put some difficult.
Huh?
Second I put some difficult.
Okay, we take it as the first item today.
My lord, I beg to mention one second appeal for order. Actually, it was listed for hearing many times, but on the last occasion, the appellant side had informed that the appellant number 1 died. So substitution is required. So 2 weeks were granted. But I have gone through the appeal and took instruction that all the sons and daughters are already there. So if it is listed for order and that portion is over, then it will be fixed for hearing, my lord.
Okay,
Otherwise,
next week,
my lord. Next week, any date, my lord.
next Monday.
Nah,
I'm bring for listing of a matter lot of 7 crore.
Huh?
Bring for listing of a matter of 7 crore.
Why?
But this matter had come up yesterday, wait for death of
What
item number 49 yesterday. The hearing.
14?
The matter of item number 49 yesterday or not.
Yes.
It's the hearing matter also of the year 2014 year.
Of RSA?
Lordship arbitration appeal.
May it please smile. For a listing of a CRP on next Monday, ma'am, for admission.
What is here?
Well, it is of the year 2016, madam. The defendants failed to cross-examine the PW 3 and 4. So the PW 3 and 4 were closed, madam. It seems challenging that order they filed this CRP, madam.
CRPIO?
CRPIO, madam. Way back in the year 2016.
When? Tomorrow?
Monday or tomorrow, any. Deeply, madam.
CRPIO.
Maybe. I think it's for listing IO or
You want it when?
next month. Next month.
No, Wednesday.
Like to mention an interested case for 61 tomorrow.
What?
Interested case.
Why?
Because my mother-in-law has filed the case. Till today, I have not been able to get the money from the key card. So it is become very much difficult.
What is the stage of the case?
The case has been admitted for hearing, but it has not been listed.
So, you'll come up for hearing. You have to file an I for early hearing if you want it. Hearing matters, don't mention it. Next.
This will I beg to mention MFA 63 of 2021 for this thing next Monday.
Why?
The matter was last posted on 29/06/2020.
For what?
There was direction to be fixed for hearing.
Hearing?
Yeah.
Hearing, no. No mentioning. You want to do it, file an IA, whatever may be, or take it out with the registry. Already we are having a lot of hearing matters. And I am a temporary judge out here. Chalo. Yes. Yes, first I'll take up the top of the list, then I'll take up his matter. Yes, what have you decided to do in this matter? Anybody appointed?
Yes.
Okay. And the government, who is the special secretary to the government of Assam?
He's re-engaged as a special secretary.
Huh?
He's now re-engaged as a special secretary.
Understood. So he is now. So he is going to take up all these matters.
It's difficult, Pradeep.
It will be difficult. I don't understand why you have done that. Yes, why did you file this IA for?
My lord, for correction of the designation and address of arbitrator by
What did I do? Instead of the divisional commissioner central Assam division to determine the dispute, now it will be the special secretary. Isn't it?
You permission, I want to support. As you already have pointed out, this under 1956 in the then there are not many cases because again, when NHI itself is more 100 cases. NHI detail is away. The same arbitrator will be again. That is the one difficult. Second point, because secretary, whenever it is been there, they're sitting in secretary. This is also continuing. This is will put their back of them because at this some nearby it's very difficult to go there, my lord, because they take generally I had seen a lot 50 occasions once secretary was allotted, he used to take it in secretary just after 3 o'clock or 4 o'clock. This
No,
very
no,
difficult
no,
for
no,
us,
he
because
can't
that is
do
to be
that.
also clarified, my lord, as you
He,
were not
this
here.
this
This might
person
be
now has
something
to be a
rare.
full-time arbitrator. He has to be a full-time arbitrator because so many cases are there.
Not many cases.
You have appointed him. Understood. First, you had the problem that he was a retired person. Now you have appointed any special secretary. So how many special secretaries the government will appoint, that is their lookout, because they only have designated the officer.
Yes.
So there is only one special secretary. The government of Assam may think of appointing more special secretaries.
Situation arise.
Now the question is the reference to be made by the competent authority to the special secretary in view of this.
Yes.
So they will make the reference. Now if it is not done within the purvey, the NHAI, DCL or anybody will lose if there is an enhancement of the amount.
Already not many cases are pending. Not many.
And they have to understand that,
Yes, that's right.
you see, today my limited scope out here is this only
That's
for
all
doing.
right.
But if I was otherwise taking a bench pipe, I would have very well further proceeded. But today my hands are limited.
It's not easy. It will observation will work out for, it will help for all.
Now,
It
in
will not
fact,
be.
if you see, Mr. Purva, I have passed the orders also. That taking into account, you say earlier, I have also passed an order to the effect.
22/124 maybe.
Yes, this court also finds it relevant to observe that at the present exists a huge filing of references to the arbitrator, and on daily basis there are various petitions filed before this court challenging the inadequacy of the compensation. Seeing the large number of litigations, both the central and the state governments shall take a decision as to whether so much of the arbitration proceedings can be decided by a single arbitrator. Taking into account such arbitration has to be in terms with the provisions of AMA, and Section 29A mandates a period of completion of such arbitration, and failure to do so would terminate the mandate of the arbitrator. So this order I have passed. Now some good sense has to prevail upon both the central and the state government.
But it might have been made observation. Regular observation. They appointed only single. If so, if they are-
No, they have not appointed a single man.
No,
Yeah.
as he has very within.
No, that I'm not going. That I'm not going to look into it. But what they have done is they have appointed a designation of an officer.
Yes,
That is the special secretary to the government of Assam. So the government of Assam may, in the fitness of things, has to appoint more special secretary for that. Chalo. The instant interlocutory application has been filed seeking a correction to the judgment and order dated 23/5/2023 passed in WPC number 6414/2013. Insofar as referring the dispute to the Divisional Commissioner, Central Assam Division, it has been brought to light that in view of the post of Divisional Commissioner having been abolished, there was no arbitrator as was appointed by the competent authority, as was appointed by the central government to decide the said arbitration disputes. In view of the filing of the instant application, this court, by various orders, had asked both the central government as well as the state government to take appropriate steps so that the appointment of an arbitrator can be, so that the mandate of the provisions of section 3G5 of the National Highways Act 1956 is given full effect. Today, Mr. Architect Chaudhary, the learned counsel, appearing on behalf of the central government, Ministry of what is that? Ministry of
Transport and Highways.
Ministry of Road Transport and Highway, had placed before this court a notification dated 21/2/2024, wherein it revealed that the officer with the designation of Special Secretary to the Government of Assam have been designated as the arbitrator for the purpose of section 3G5 of the National Highways Act 1956. The said notification, which was placed before this court, is kept on record and marked with the letter X. Taking into account the above, this court therefore modifies the judgment and order dated 23/5/2023, passed in WPC number 6414/2023, to the extent that the reference so directed to be made to the Divisional Commissioner, Central Assam Division, shall mean the Special Secretary to the Government of Assam as appointed by notification dated 21/2/2024. With the above observations, the instant application stands disposed. Before parting with the record, this court, however, finds it very relevant to observe that there are a huge number of cases under the provision, in a huge number of references which are to be decided by the arbitrator in terms of section 3G5 of the National Highways Act 1956. Delay in disposal of the said applications not only would entail accumulation of interest if the amount is adjudged to be higher than the amount which have been awarded. Apart from that, this court also takes note of section 3G6 of the National Highways Act 1956, which categorically mandates that the arbitration is to be carried out in terms with the provisions of the Arbitration and Conciliation Act 1996, meaning thereby that Section 29A of the said Act of 1996 would come into play, and the consequential effect thereof would be that there is a period within which the arbitrator has to decide the reference. Under such circumstances, this court is of the opinion that both the central government and the state government shall take an appropriate decision, has to take an appropriate decision, so that the arbitration proceedings which arises in terms of Section 3G5 can be of the National Highways Act is decided, can be decided at the earliest by appointing more special secretaries of the to the government of Assam for deciding the same. This court also finds it relevant to take note of the submission of Mr. C. Borough, the Learned Counsel, appearing on behalf of the National Highways Authority of India, who submits that the arbitrator who would be appointed has to take up this, the arbitrator who is appointed has to take up these arbitration proceedings. And that the special secretary who would be taking up these arbitration proceedings has to dedicate most of his time for the purpose of disposal of these arbitration proceedings, and cannot be made as a stopgap arrangement in as much as there would be a delay in deciding those arbitration proceedings. Under such circumstances, he submits that a proper office of the special secretary of the government of Assam should be appointed. There should be a proper establishment for the special secretary for the government of Assam only to deal with these arbitration proceedings. Taking into account the limited scope in which this court is dealing with the instant application, this court would leave it to the wisdom of the state government to do the needful so that the arbitration proceedings can be brought to arbitration proceedings pending before the special secretary the arbitration proceedings referred to the special secretary to the government of Assam is in a position to decide those arbitration proceedings, giving due opportunity to both the parties. For that, the state of Assam would be required to have a proper establishment for that purpose, which this court leaves it to the wisdom of the state of Assam to do the needful.
Will help us.
With the above observations and directions, at least something has been done.
Yes.
Otherwise, there will be a lot more cases out here. Yes, Mr. Dilip Majumdar, where is his matter? Item number 19. I can't help it. He only asked for. What is this matter about?
My lord, the petitioners as the defendants filed an application order 7 Rule 11
Yes.
for rejection of the plaint,
Then,
and that application was rejected.
so yes, before this court,
Yeah, before this one.
let us see what is
Yes,
this
ma'am.
application.
My lord,
Where is your plaint?
plaint, my lord, your lordship will find at page 18.
Page 18.
18 to the main petition.
Court of the. This is a commercial dispute.
Yes, commercial.
Well, and there is a state to the commercial dispute.
Yes,
Then
Then my
what
lord,
is the ground?
ground that this honorable court, the learned trial court has no jurisdiction to entertain this suit, my lord.
Why?
And my lord, that is the ground which they have taken.
They
Their
can't say it is
petition,
a
their
jurisdiction.
petition is at page 65, my lord, which they have filed.
Their application.
Yes, 65.
Yes.
I'm sorry, but
Why have you filed this application?
Uh,
For rejection of the plea?
no, provision has been mentioned, but in course of argument, we have indicated that we are basically challenging the mentality to.
So they will have a preliminary issue and decide that.
Well, that was decided.
This is the preliminary issue decided.
Yes, ma'am. Yes, ma'am. Because in course of argument, we say the provision has been mentioned, order 711, but we are basically challenging the mentality of the school.
Has the issues been framed?
Issue as such, but it has been decided.
Now, how can it be decided?
And we pray that preliminary issue may be framed and decided, but court.
No. First and foremost, where is the question of deciding a preliminary issue without the preliminary issue has to be done under Order 14 Rule 2?
Yes, yes.
Then
Well,
under
I
such says
indicated-
that without the framing of the issue, how is it possible to do it?
Well, in case,
And how does Order 7 Rule 11 has anything to do?
we follow the application was filed under order 7. In course of argument, I indicated, that order 7 is such as we are not pressing. We are saying that court doesn't have territorial jurisdiction. Accordingly, there's continuable. It has to be returned. That point has been decided otherwise. Preliminary issue as such under order 14 has not been framed and decided. But
So if it is not
No.
framed, how can it be
No, my
decided?
lord, no preliminary issue.
Then-
has been framed.
Lordship may kindly have a look at the order.
Where is that order?
Start from page 223,
Page
223.
2, 3.
Hello, page 2 to 4, the operative part, one paragraph in.
3.
2 to 4, if your lordship turn. Next,
Uh.
the second paragraph. From the contents of the petition filed by the defendant's petitioner, it reveals that the defendants have challenged the maintainability of the suit on the ground that the cause of action to execute the same has arisen within their territorial jurisdiction in the state of Himachal Pradesh. Therefore, the question raised by the defendant to reject the plaint under the provision of Order 711A doesn't arise. So far, the question raised by the defendant regarding territorial jurisdiction of this court to try the suit is concerned. I have gone through the cause title of the plaint. From the cause title of the plaint, it is apparent that the address of the defendant number 1, as well as rest of the defendant, is shown at Guwahati. Moreover, the address of the plaintiff is shown at Guwahati. Record further reveals that the summons to the defendants were issued at Guwahati address, although the same were refused. However, record further reveals that the defendants have appeared in the main suit on the basis of summons issued through normal process at Guwahati address. That being the position, it can be safely held that the defendants are carrying on business at Guwahati apart from the Himachal Pradesh. As such, this court has territorial jurisdiction to try this in terms of order section 20A of this case. In the entire plaint, your lordship will find they have not said a single word there. The cause of action has arisen within the territorial jurisdiction. If the plaintiffs are.
Are you going on the question of Order 7 Rule 1 F?
Section 20, lordship kindly.
Section 20 is different. Section 20, any part of the cause of action arises.
No part of cause of action is arisen here.
That is not that. What do you say about Section 17 and 16, where one of the defendants resides?
No, defendants do not reside here, man. They have got an office here, but.
We are to see, we are to believe the plaint as it is.
Yes.
So whether it is there or not, that is a subject matter of proof.
My lord, here, I'm referring to section 20 for one reason. If it is a company, section 20 expression provides that if it is a company
Huh.
and if it has got a principal office in one place and it doesn't have any subordinate office, then this has to be filed in the court where the jurisdiction is an origin principle. And the Lord is aware of it. And here is a case where our principal office and registered office is in Guwahati, Arunachal. Goods were supplied from Calcutta to Arunachal. Goods were received at Arunachal. Work was carried out in Arunachal. Now they have filed the suit saying only that one before the legal services authority they filed some application, and that because of that this cause of action is raised. Nothing else other than there is nothing.
But all these addresses are given of Guwahati.
They have given my lord deliberately so as to file the suit here in
So
Guwahati.
under such circumstances, deliberately, rightly or wrongly, can this be done under Order 7 Rule 11? No.
That's why I say, Order 7
Even if we go by that judgment of the Supreme Court, wherein it says that if you are to decide a preliminary issue where there is, you are to take the contents of the plaint as to be
yes,
truth.
sir, I'm only on that. I'm saying that contents of the claim can be considered
Then,
and seen whether any cause of action has arisen within the
without the issue being framed, where is the question? What is
Well,
the wrong?
issue- well, I in fact argued and insisted that preliminary issue may be framed and then said court went ahead with the hearing of the matter and decided the issue.
May I intervene, my lord? No such prayer has been made, my lord, and no preliminary issue has been framed.
Let us not go into all these. We don't
But-
find any good ground to interfere with the order dated 9/5/2000.
Well, Lord may kindly have a look at section 21.
21 is raising the first dispute at the earliest.
No, 20.
20 are
20
three things.
explanation, my explanation.
Huh?
Explanation.
Yes. Explanation is as regards if a part of the branch office.
Yes, ma'am. Yes.
Oh.
And here is a case, ma'am. We have the principal office, we have the registered office in Arunachal. And other than this, ma'am, we don't have any branch office here. And in the proceeding also, they have nowhere said that you have got a branch office here, you are carrying on business here. Only thing is they have deliberately given because the company.
Mr. Mazumdar, you know what to do, how to take it up. Take out, initiate the proceedings and I don't need to tell you.
Well, my learned friend is disputing. My learned friend appeared. I appeared before the court below. I said that we are paying order application was earlier fine under order 11. I on the first day said that it's not an application under order. We are challenging the maintainability on the ground of want of
But
jurisdiction.
maintainability on the ground of there has to be an issue framed.
My lord, that I agree.
Once an issue is framed, or you have already filed your written statement, issues have to be framed, and on the base, your application on the face of it has to be rejected under Order 7 Rule 11, and can you thereafter, on the basis thereof, come before? You are challenging the order dated 9/5/2023. What is wrong in this order?
My lord,
Absolutely right. As of on the basis of
my lord,
so I can very well say that they may very well frame a preliminary issue as regards that if it is deemed fit and shall not be influenced by the order of this. That's all, nothing else.
my lord, on
Commercial suits. Now the next is how much is the cost? Commercial suits, when we dismiss proceedings before this court,
Madam,
we have to impose costs.
in substance, my lord, this order is an order on the issue of territorial jurisdiction.
Mr. Majumdar, this order emanates from a proceedings under Order 7 Rule 11.
That-
Order 7
My
Rule
lord-
11 does not show in any manner that a territorial jurisdiction aspect can be taken into account.
I agree, madam. I indicated your lordship from the tenor of the order itself, it appears that I indicated that I am not insisting on order 711. I am only saying that it's not maintainable and I'm saying.
Can it be done in this manner? What you are asking, can it be done in that manner?
Madam,
Let us say,
Madam,
we may wait. Now we have a change with the criminal laws. A few days thereafter, the civil law. Should we keep this matter pending till then?
No, madam, what I'm
Let me
saying,
dismiss this now.
well, if your lordship says that the court below will frame on this point a preliminary issue and then decide, then I have got no difficulty.
I would never say so. I would say that the court will frame preliminary issues if on the basis of these facts, and if it can exercise the powers under Order 14 Rule 2, it can do it. That is, I think we should leave it to the best wisdom of the courts.
Madam, technically, your
First
lordship
of all,
is correct,
all the
madam.
issues are to. be
And
framed.
if only I can help you with only thing, the observations made in this order shall not influence in the decision of this. That's the best you can get.
In fact, the moment I entered, I said that this order 711 is not the application proper.
Okay. That's the small matter pending for such long. heard Mr. D. Mojumdar, the learned senior counsel, assisted by so and so, and Mr. O.P. Bhatti, the learned counsel, for the petitioner, on Mr. O.P. Bhatti, the learned counsel, appearing on behalf of the respondents.
Only one.
The instant proceedings arises challenging an order dated 9/5/2023 passed by the Court of the Civil Judge number 2, Kamrup Metro at Guwahati, whereby the application under Order 7, Rule 11A and D, bracket A and D, of the Code of Civil Procedure 1908, for short, the court, was rejected. This court have duly perused the application which have been filed under Order 7, Rule 11, A and D, and primarily a perusal of the said order, say the application, shows that the basic grievance, the basic ground taken is that the court before whom the suit was filed did not have the territorial jurisdiction. The question of territorial jurisdiction, in the opinion of this court, cannot be decided in the proceedings under Order 7, Rule 11A or D. Under proceedings under Order 7, Rule 11. Inasmuch as the same may require going into evidence, and more particularly in a circumstance of the present case where there are statements where it has been categorically shown in the plaint the defendants the defendants are either residents or has the principal place of business within the territorial jurisdiction of the court of the court at Guwahati. It is a well-settled principle of law that when an application under Order 7, Rule 11 is taken, the only document which requires to be looked into is as to whether it is the plaint, and from that said plaint, whether the plaint discloses a cause of action, or for that matter, whether from a perusal of the plaint appears to be barred by the provisions of law. Under such circumstances, this court, having perused the impugned order dated 9/5/2023, finds no illegality or an error of jurisdiction in passing the impugned order, for which it is the opinion of this court that this is not a fit case for exercising the jurisdiction under Section
115.
Section 115 of the Code, or for that matter, under Article 2 to 7 of the Constitution. Consequently, the instant proceeding stands dismissed. The stay order dated
9/5.
23/5/2023 passed in the instant proceeding stands vacated, and taking into account that the parties are duly represented before this court, it is directed both the parties shall appear before the trial court on 27/3/2024.
My lord, this matter is fixed day after tomorrow. Before
There is a stay. How can it be fixed? There is a stay till
For-
returnable
for-
date for
for
the proceedings.
protection
have
of the
been
order.
fixed. Huh?
For protection of the order. For necessary order.
Absolutely no. We'll fix it on 27th.
Order.
27, because we can't take judicial notice that the court is still proceeding when the proceedings have been stayed. 27. Before parting with the record, this court, however, finds it relevant to observe that if the petitioners who are the defendants in the suit wishes to raise the question of territorial jurisdiction, the same can be very well framed as an issue, or for that matter, a preliminary issue, if no facts are disputed. This court, however, further finds it relevant to observe that while adjudicating the issue, finds it relevant to observe that the order dated 9/5/2023 is an order which is confined to an adjudication of a proceedings under Order 7 Rule 11. And the findings thereof shall not, therefore, influence the learned trial court while deciding the preliminary issue while deciding the issue of territorial jurisdiction in the suit.
Right.
For admission item number 2.
Yes, what is this?
Lordship, the plaintiff of a suit was dismissed and on appeal it was remanded back on a specific issue. Lordship. Thereafter, I would like to take the Lordship to page 37. Page 37. This is not the impugn order. This is the development. There are 3, Your Lordship. The plaintiff was directed to submit her additional evidence by this order. There are 3 of page 37. Thereafter, Lordship, subsequently page 48, Your Lordship, may tell us. This is another order, subsequent order. I prayed for commission since the plaintiff was 90 years old at that point of time. So commission was allowed considering page 48, para 1, 4th paragraph. Thereafter, page 53, Your Lordship. Page 53 is a part of another order. The 4th para again, Your Lordship. The cross-examination was kept in abeyance till the examination of the official witnesses was done. Sub-register was to be examined. Thereafter, I'll take Your Lordship to
Sir Mukherjee,
impugned order.
kindly come to your.
Lordship. Now the
We will go into back to that point
now the impugned order.
only after we first know why are you agreed.
Lordship. Now
Why
the
are you agreed?
page 56 here.
Page 56. Yes, what is it?
Lordship, here the learned court below has rejected my additional evidence stating that I have went beyond the pleaded case, Your Lordship, and I have went beyond the pleaded case. The additional evidence was rejected.
Where?
Relevant portion with, if I may read from page 56 of the entire order.
Who is this? This is the again the trial court.
That's right.
Now, additional evidence is given where?
In the trial court, the case was remanded back to the trial
For deciding.
for deciding.
Then,
Then, Your Lordship, I adduced additional evidence that was taken on record. I prayed for commissioning since that was also allowed. And thereafter, the official witnesses was conducted. Thereafter, I prayed for an adjournment for cross-examination since she was an aged lady. And my petition was rejected. And also my additional
your
evidence
petition was rejected.
rejected.
For?
Since so many adjournments are taken. it is
Okay,
noted
then?
here. And also my additional evidence was discarded, Your Lordship, on the ground that the additional evidence was filed beyond the pleadings.
Where is that impugned order?
Lordship, the impugned order is starting from page 56, Your Lordship. And the relevant portion,
You are challenging which order? Now?
page 56, 411
Only 56.
only.
Now 56, what did they say?
56 from the last
Plaintiff
paragraph.
is a defendant stated the plaintiff is a fool and suffering from a year for which he has failed to appear before the court for high peril. The plaintiff has already sought several establishments of the hence indirected they are the plaintiff submitted
Sit down.
So we were agreed by
By,
first your additional evidence on affidavit.
that was not accepted.
Why? Because you have delayed. Rightly so. So what is wrong?
Lordship, for that, your lordship, I would like to take your lordship to the previous date.
How many dates you have taken?
I have not taken anything. The petition, from the very first date, there was a prayer that it should be examined by commission. It was allowed. I deposited the cost as well for commissioning. And then it was deferred till the official witnesses are conducted. And after it was deferred, I filed a petition that she is an aged lady, she cannot come to court. That was rejected. She was not required to come to court. In fact, it was to be conducted by commission as it was deferred till the time the official witnesses were completed. It was completed. Now it was to be examined by commission. So my petition was.
Then why didn't you point it out before the court that you had to?
That was
There is already an order. Then?
That was a mistake on my part.
And the mistake is to bear expenses, consequences.
But there were orders, your lord. There are
So
previous
what?
orders allowing.
You have not pointed out. Either you pay the cost, Mr. Mukherjee, or let your client pay.
Lordship, the petition that I filed on the last date, your lordship, it is page 50.
Either you pay. Somebody has paid up. This is relating to what property?
Lordship, the title suit is filed by the mother against a gift deed given by her to the son, stating that he only intended.
You are the mother?
I'm the mother,
What is your age?
92 years, sir.
Then how can you go? Means that it has to be done by the commission.
It has to be the same. That is,
Then why the court did not look into it?
there was an order allowing.
So we can't impose the lady. We have to impose Mr. Mukherjee. You depose. This order is wrong.
Already,
Well,
it was
ask
allowed.
Mr. Mukherjee to pay you 50,000 for me. You pay. It's your mistake, the lawyer's mistake, not the mistake of
Lordship,
the
the
lady.
lawyer did not point out.
Yeah, absolutely. So it is your burden. You must have taken that lawyer must have engaged you. So you are in close connection with that lawyer.
Let's say it was not pointed out, but there were
So
orders.
you pay
there.
that. You pay him 50,000.
Orders were there.
Huh?
There were orders already. I did not
Understood.
point it out.
So it is not a mistake of the person. And what is this? This Kokraja judge, they don't know head or tail. When evidence is required, doesn't he want to keep his
not come to the
mouth
record.
shut and take it up out there when he has to decide in the trial? Instead of that, before that, he's rejecting the evidence right, left, and center.
After allowing that.
Huh?
After
Can
allowing
he,
it,
can he reject
review his own.
an evidence before considering it at the time of argument?
Only thing is that, my lord, here
After
was-
coming back again to bench one, I'm really very disappointed with the lower judiciary. I think something must have improved for the last 2 years. It's again back to square one. How is it possible? And this 92-year-old lady, by the time everything happens, she might die. So we impose the cost upon Mr. B.J. Mukherjee, 50,000. All because of your fault.
Lordship may consider the.
Huh?
Lordship may reconsider the amount.
No. There's no reconsideration upon the lawyer. The lawyer is the sole source of problems is
Understand,
because of you.
but-
Why didn't you point it out before the court? Then look here, this is the thing. There is already an order being passed. There has to be sent for commission. And if the lawyer goes out there and says before the court that she is an old lady, she can't come. Although there is already an order. It's all because of you.
Yep.
So the cost is to be paid by you. Of this 50,000, you pay 25,000 as compensation to your client and 25,000 to Mr. Iqbal. Justice is well served.
Lordship may reconsider the.
No. Nothing
Considering
doing.
the valuation of the.
My goodness. It's all because of you this has happened. A 92-year-old lady has suffered. You take it from your friend who has engaged you. And now tell me another thing. She's a 92-year-old lady. When she can appear before the cross-examination in the commission,
Any day.
what any date? Again, she will, after she's a 92-year-old,
Before the commissioner at her residence. Her residence.
obviously the residence, it has to go on in that manner.
Yes.
Chalo. Now, the instant proceedings under Article 2 to 7 of the Constitution is 5, challenging the order dated 4/11/2022 passed by the Court of the Municipal number 1 Kukraja in title suit number 22/2010, whereby the learned Munsi, the learned trial court not only refused to grant an adjournment on account of the cross-examination of the plaintiff, but also rejected the entire additional evidence even prior to considering the same, while even prior to the arguments to be made in the said suit. This court have duly taken note of. This court have perused the order dated, the judgment and order dated 23/10/2019, passed in title appeal number 1/2017, whereby the learned court below, whereby the learned first appellate court, that is the court of the civil judge Kukraja, had remanded the suit and directed with a direction for fresh trial of the issue framed by the appellate court. Had remanded the suit with a direction for fresh trial and also deciding the issue which was framed by the appellate court. Pursuant to the said judgment, the petitioner, who was the plaintiff, had submitted her additional evidence on affidavit and also made a prayer, also filed a petition under Order 26, Rule 1 and 2, and 1, 2, and 8 for examination of the plaintiff on commission. The said by an order dated 3/12/2021, the learned trial court you filed the petition for commission before. My goodness. Pursuant to the said judgment, the petitioner filed an application under Order 26, Rule 1, 2, and 8 for submission of for adducing additional evidence by way of commission. This application was registered and numbered as petition number 499/2021. The learned trial court by an order dated 3/12/2021 opined that the petition being petition number 499/2021 would be taken up for consideration after filing of the additional affidavit on evidence by the plaintiff. Pursuant thereto, the plaintiff filed her evidence on affidavit, additional evidence on affidavit. Subsequent thereto, by an order dated 28/1/2022, the learned trial court disposed of the petition being WPC petition number 499/2021. Thereby observing that the case made out by the petitioner was a fit case for issuance of commission to examine her and more particularly keeping into account the old age of the plaintiff public petitioner. The learned trial court further, by the said order dated 28/1/2022, appointed an advocate, Srimati Lolita Nazare, as the advocate commissioner to record the evidence of the plaintiff in her residence. Subsequent thereto, on 4/3/2022, on account of the prevailing COVID situation, the cross-examination of the plaintiff through commission was deferred. Pursuant thereto,
Was allowed.
pursuant thereto, by an order dated 4/3/2022, in view of improvement in the COVID situation, the commissioner was directed to examine the plaintiff through the commissioner was directed to proceed proceed for examination of the plaintiff, thereby fixing 21/3/2022 for payment of cost. On 21/3/2022, the plaintiff duly deposited the cost And the court fixed 12/4/2022 for report of the commissioner. The report further reveals that the plaintiff thereupon was not cross-examined, or the commissioner had submitted a report. And accordingly, on 18/5/2022, the said aspect of the matter was duly recorded. It was further recorded in the said order that it was essential that the sub-register Kokrajhar should bring the volume of the gift deed and all relevant documents in his office in connection with the gift deed bearing registered number 372/344 dated 26/3/2009. And till completion of the examination of the sub-register Kokrajhar on the said gift deed, the cross-examination of the plaintiff on her additional evidence on affidavit was to be kept in abeyance. Accordingly, by the said order dated 18/5/2022, notice was directed to be issued to the sub-register Kokrajhar and fixed 15/6/2022 for examination of the sub-register Kokrajhar. It is not known what happened thereupon, as the records do not speak. Be it as it may, on 4/11/2022, a petition was filed on behalf of the plaintiff stating that the plaintiff is an old woman and suffering from various ailments for which she has failed to appear before the court to face cross-examination. The trial court, by the impugned order dated 4/11/2022, rejected the said application seeking adjournment on the ground that the plaintiff had sought several adjournments for cross-examination of the plaintiff on her additional evidence on affidavit on the same ground. Not only that, the learned trial court further went ahead to hold that the evidence on affidavit, as well as the additional evidence which have been tendered, was to be disregarded, was rejected. As the same was beyond the pleadings. Mr. Iqbal, what happened in between 18/5 onward?
My lord, maybe they had taken time, my lord.
Official witness.
Official witness was cross-examined, my lord, sub-register and others.
Was he cross-examined?
Yes.
And then?
Thereafter, my lord, they filed this application that they cannot come before the commissioner because of the old age. My lord.
And they did not say that there was already an order of commission.
That part, my lord.
This court have duly heard the learned counsels appearing on behalf of the parties. Gusto. Admittedly, the plaintiff is 92 years old. And this very aspect of the matter was duly taken note of by the learned trial court in its order dated 28/1/2022, wherein the application for appointment of a commissioner to examine the plaintiff was allowed. It is, however, very surprising to take note of that the learned counsel who was representing the plaintiff did not point out this order before the trial court, which led to the trial court passing the impugned order dated 4/11/2022. Apart from that, another very important aspect of the matter, which this court finds it relevant to point out, is that the appreciation of evidence, whether the same is required to be taken or not, and how it is to be appreciated, should be done at the time of delivery of judgment. However, surprisingly, the learned trial court rejected all such evidence which was placed subsequent to the remanding of the suit by the impugned order, which on the face of it appears to be an exercise of power, an exercise of power with material irregularity, exercise of jurisdiction with material irregularity. Considering the above, this court sets aside the order dated 4/11/2022. This court further directs the parties to appear before the learned trial court on 19th of March 2024, on which date the learned trial court shall fix a date for cross-examination of the plaintiff on commission, and for fix a date for submission of the report on commission, and further direct the commissioner so appointed to complete the said cross-examination on or before the next date so fixed. This court further observed that the learned trial court may also direct the learned commissioner to be appointed to submit a report if, on account of any if either of the parties is not willing to cross-examine is not willing to take part in the said cross-examination. Thereupon, the learned trial court shall proceed with the disposal of the suit. This court further observes that the learned trial court shall decide the said suit without being influenced with the order dated 4/11/2022. With the above observations and directions, the institution stands allowed. Cost.
Briefly obliged.
Look, there's not in dispute method.
Hmm.
In a trial court, we will file application for calling for the intake as a record method. So they rejected. We then file an appeal method after the judgment and to ground method regarding that. Thereafter, method we apply for certified copies of the intake report. And ultimately, method we file an application to the appellate court to grant some time so that we can file the application for additional evidence. That the law still find method at page 84.
Where is the impugn order?
Improve order page 86.
Where is the order sheet of the trial court, appellate court proceeding?
It's not an extent.
None of you have it? Oh, it's there.
Only three orders.
Yes. Why so delayed?
Well, in fact, we applied for certificate copy.
Have you got the certified copy? Have you
Have
got the certified copies?
No,
Because
no.
you say that you have applied for certified copies on 15/12/2023. Have you got it?
Not all.
Yeah.
Not all.
What not all? How many you have got it?
About 20 ballots. About 20.
Yeah.
Malad, your losses will see, Malad, that what the trial for a
The trial appellate court has been absolutely right. You have not taken all along, the matter has been fixed for hearing. Why haven't you filed your application under Order 41, Rule 27 at any point of time earlier? All along, the time has been taken only on the ground of adjournment of the council.
So, Malad, yes, your lawsuit say at page 86. He
I've
said,
seen that
Malad,
order.
My lord,
No, it is not a case for exercise of jurisdiction of the two.
my lord, my lord, what in the objection also they've taken. Furthermore, NJ cases for which appellant was to bring on record, it's not necessary to decide the matter. My lord. Since the appellant was declared to be defaulter for non-payment of rents for some months of the year 2013. If, my lord, it is concluded that only that will be considered, not subsequent, my lord, I have nothing to say, my lord. The appellate court rejected on this ground also, my lord.
Forget about the other ground, but why didn't you file your Order 41 Rule 27 application? In fact, that application should have been filed at the time of filing the appeal. It is nothing but a delay. It's on the face of it. It is only a point for causing a delay to the appeal hearing. They have submitted the written arguments long time back there. Private, you have been all along taking adjournment that my counsel is not well. This time the counsel is not well. What is this? You should have thought about it filing an application, and you will file an application at Order 41. I would have understood that you have come up with an application at Order 41 Rule 27 and the court did not consider that. Then the question would have been different. No?
No, my lord, we have applied for certified copies, my lord.
Oh. You have applied for certified copy. You knew on the date on which you have filed the appeal that these documents were necessary. Isn't it? It is on the face of it. But did you now are you trying to develop? Because if you see the provisions of Order 41 Rule 3, isn't it? Order 41 Rule 3 or 4, which says that the grounds on appeal has to be those, and if you want to have any additional grounds, you are to amend your memo of appeal.
We have taken those
Then-
down, my lord.
You have not done that.
No, we have taken those down,
And if
my lord.
those you have taken out there, why on that date you did not file your application under Order 41 Rule 27 or thereafter? This is not a fit case for exercise of 227.
No, my lord, the ground for rejection, my lord, that your lord,
Grounds of rejection is absolutely proper.
my lord, it is only for the purpose of 2013, my lord.
No.
And
No, I understood. If that was your ground out here, where is your ground? Let us see the ground of appeal.
my lord, that is page 76 and 77.
Page
Page 76, 77. P and Q.
Then why didn't you file your application if these are the grounds? Why didn't you file your application under Order 41 Rule 27? You are going to file an application in future after the written arguments are over.
But yes, I thought was not it, my lord, by that.
No.
My lord,
Then your grounds which you are making has no basis. You could have very well filed an application under Order 41 Rule 27 calls for those records.
my lord, it's the appeal of 23, my lord, not the appeal of 23, my lord.
Application?
Appeal was of 23.
Oh, rightly.
My lord.
You don't want the court to do it early.
No, that is not the ground.
Okay, we will take it. That whenever Mr. Sahewala's matters comes of 2020, 21, we won't take up those matters if he is any urgency. So,
No, not that.
or we can do one thing, we can vacate this order and not dispose it of. This is a 2023 matter. Let us vacate
Not
this
that,
order.
my lord. I'm,
No, let us vacate this order and
No.
then do one thing.
no, I'm
We
saying, my
vacate
lord,
this-
the appeal
Then-
was, appeal was filed in 2023, that is why, my
So
lord,
what?
put the filing.
Mr. Sahewala, if it was your grounds, you should have to be active enough to file that application immediately along with the filing of the memo. That is actually what is required to be done. If you are making the as the basis. Landlord tenant, what is the landlord? What is the tenancy?
There is four line, my lord.
There is no four kinds. Mr. Sahewala
No,
being the counsel.
I'm not, I'm appealing.
Huh?
83 years old.
83 does not make any difference of that.
No, not backing, but it's more, my lord.
Why do you want to still keep something to a place now if it is an 83-year-old?
Very small profile.
Where is the decree?
Yes, ma'am. That is 20,
Page
page 22, my lord. Take that as well.
52 is the judgment. Where is the decree?
Yes, sir. Yes, sir.
Yes, what to do? You are having a good shop out there.
My lord, very
9
small.
by 16
My lord.
at GNB Road. Carrying on the business
The
of
market, my
ready-made.
lord, very small.
You can't be poor.
Small.
What small? You want to have a showroom? Huh? Yes, Mr. Roy, what to do?
My lord, your lordship has rightly say, observed that it is only to delay. My lord, I'll just point out one finding of the landed trial court, my lord, at page 42. Page 42, lordship kindly come to page 42. His lordship got it, my lord. Fourth line. He further stated that he has not filed any document to show that he has paid monthly so and so. Thereafter, he further stated that he exhibited challan, but has not called for NG case records. So during the trial court and during cross-examination, he specifically said, I did not call for record of the NG cases. That was cross-examination was on 29/6/2019. Thereafter, my lord, they may not reduce DW2 evidence. Then also did not do so. When the court was finally heard, fixed for judgment, there before the trial court, he filed the application, my lord, for my lord, calling for those records, my lord.
And that was rejected.
That was rejected. He has taken this ground, my lord, in appeal. That ground will be heard. He can very well take under section 105, my lord, if he has taken, that will be heard. So what did he do? Even if lordship has had it, at the time of filing the appeal, he could have also do that. He didn't do that.
We do one thing, we set aside this, we dismiss the petition. However, we observe that the observations made in as regards the merits shall be decided. He shall decide the suit without being influenced by the observations made in the second.
My lord, we have submitted argument, we submitted a written argument.
Without being influenced by these,
Lost everything.
they'll dispose of
Yes,
this.
yes.
Because I would have understood. If it was an application filed under Order 41, Rule 27, the court had rejected, I would have very well
That's
taken it.
right.
But not that he's filed the petition, he's going to file one day. When it will happen,
After
it is
3
not
months.
known. Chalo. This is an application under Article 227 of the Constitution. Challenging the order dated 15/12/2023 passed by the Court of the Civil Judge Senior Division number 1 Kamrup Metro at Guwahati in title appeal number 6/2023, whereby the application seeking adjournment to file an application for bringing to file the relevant case NJ records was rejected. A perusal of the materials on record reveals that the petitioner herein was the defendant in title suit number 334/2014. The said suit was filed for eviction of the petitioner, defendant, and for recovery of area rent. The said suit was decreed by the judgment and decree dated 30/11/2022, holding inter alia that the petitioner oblique the defendant was a defaulter in payment of rent, as well as also holding that the plaintiff had bona fide requirement of the suit premises. Being agreed by the judgment and decree dated 30/11/2022, the petitioner as appellant preferred an appeal before the Court of the Civil Judge, Senior Division number 1, Kamrup Metro at Guwahati, and the appeal was registered as title appeal number 6/2023. It is relevant herein to take note of that along with the appeal, the petitioner did not file any application under Order 41, Rule 27 for adducing additional evidence of the code. For adducing additional evidence, thereupon the appeal proceeded for hearing. and the respondent completed his hearing, and the respondents therein, the respondents herein, who were also the respondents in the said appeal proceeding, had completed the hearing, and also submitted the written arguments. Thereupon, it further reveals from the order sheet, which is enclosed to the petition as Annexure 3 series, that even during the time of earlier hearing of the respondents, no application was filed under Order 41, Rule 27 of the Code. Rather, when the matter was fixed for further arguments, an application was filed on 15/12/2023 that the appellant, that is the petitioner, would be filing an appropriate application for calling the LJ cases. It is under such circumstances the learned trial first appellate court rejected the said application and fixed 19/1/2024 for a judgment. Thereupon, the petitioner had approached this court, and this court had issued notice by an order dated 21/12/2023, and also state the further proceeding of title appeal number 6/2023 till the next date. In the backdrop of the above facts, this court has also heard the learned counsel appearing on behalf of the petitioner, Mr. J. N. Sahewala, the learned senior counsel, as well as Mr. P.K. Roy, the learned counsel appearing on behalf of the respondent. And have duly noted their arguments. This court have also perused the judgment of the trial court dated 30/11/2022, and more particularly to the cross-examination of the petitioner, who was the DW1 in the said proceedings. During cross-examination, he submitted that the petitioner had exhibited certain challans but did not call for the NJ records. It is also stated at the bar that after the completion of all evidence, an application was filed before the learned trial court for calling for the NJ records, which was rejected. And it is on the basis thereof, grounds P and Q were taken in the memo of appeal. Under such circumstances, if the petitioner oblique the appellant was aggrieved, the petitioner or the appellant ought to have, along with the memo of appeal, filed the application under Order 41, Rule 27 of the Code for adducing additional evidence, which was never done even at the time of the arguments even after the completion of the arguments of the respondent, an attempt was made then to call for the records of the NJ case. Under such circumstances, this court, while exercising the jurisdiction under Article 2 to 7 of the Constitution, finds no ground to interfere with the order dated 15/12/2023, for which the instant proceeding therefore fails. This court, however, finds it also, but before parting with the record, this court, however, finds it relevant to observe that, taking into account that the petitioner herein have not advanced their arguments, it is the opinion of this court that the interest of justice would be met if the petitioner herein, who is the appellant entitled Appeal number 6/2023, be given a opportunity to make his submissions in the said appeal. Accordingly, this court fixes the matter on 23/2024 before the learned first appellate court, on which date both parties shall appear, and thereupon a date may be fixed by the learned first appellate court as per its convenience for hearing of the appellant. The appeal thereupon. This court also finds it relevant to observe that while disposing of the said appeal, the learned trial court, the first appellate court, shall not be influenced by the order dated 15/12/2023, more particularly to the observations as regards and to the order dated 15/12. With the above observations and directions, petitions that
Interim order inspected.
I've directed them in view of the above, the interim order stands.
Observation of this order also, my lord.
Eh?
Observation of this order also.
Which one?
Observation.
Observations made. Interim order stands. Shall not be influenced by the observations made in the order dated 15/12 legislation, as well as the observations made herein.
Item 23.
Oh, what is this matter?
Injunction appeal.
First appeal
First step.
against
Against the
39 Rule 4.
my lord. So what has happened, my lord?
There's an order passed under 39 Rule 4.
My lord,
You're challenging it,
page 159.
and there's a miscase.
Yes,
Miscase?
with case number 21 of 2020 before the court.
Miscase?
No, my lord, because you're okay, I'm not praying for anything.
What are you asking for?
But I'm challenging the order because my application was rejected by the court.
Your application was rejected.
Order 39 Rule 4.
So if your application means for vacating has been rejected, then whether the judge order has become final? So against which order you are challenging then?
Against ex parte order. Ex parte order.
So then the proceedings are pending.
There is a difficulty, my lord. That's why I'm just giving you a lot of the background. Suit was filed by one gentleman. The prayer is that the declares that he is the sole owner of some equity shares of different number 1 lying in demat account of number 2 and so. And the plaintiff as well as daughter, who is different number 2.
This is the suit, title suit 41.
Yes, ma'am. Page 16.
But this person has died.
He has died. Now what happened, my lord?
Because there's some other matter which came up before me.
What's the
Some injunction order was passed.
yes, ma'am.
No, there was an application filed for rejection of the plaint or something to that effect.
Well,
And that
possibly-
was rejected, and here a revision was filed by one DJ Das. Is it connected with
Another method is making it.
then I said that without impleading, nothing happened, so I closed that CRP. Some lawyers from Calcutta came.
Yes.
Yeah.
Here this is very interesting. Defendant number one is the company of which he is having shares. Shares are in the joint name of the plaintiff as well as his daughter, who is defendant number two. Now, during the pendency, initially there was an injunction that the injunction was raised that the defendant, particular defendant number two, could not sell the shares. His prayer is declares that he is sole owner, although it is lying in the joint name of himself as well as the daughter, defendant number two.
Hmm.
Now, the injunction was granted saying that additional injunction status to settle in. Now, I am not allowed to enjoy the share 27% stake I have with the company. Now, other dividend, I don't know whether it's excluded or not because of the
But
status.
whether that plaintiff has been substituted.
No, when plaintiff has died, his other legal heirs are there. They are not interested.
So then what remains in the suit?
Nothing remains, but the difficulties, so many difficulties are there.
The suit
One
should have
gentleman-
awaited.
One gentleman who has filed a probate petition on the basis of a will allegedly executed by the plaintiff in Calcutta High Court that is pending for last 10 years, is not taking steps. He filed the application for substitution. We oppose. Substitution was kept in abeyance, saying that until and unless that probate petition is finally decided, we are keeping in abeyance. Side by side, by an observation, this also is kept in abeyance.
Then
That order was challenged before some court, rejected order. Against that, we did not put.
substitution.
Substitution remained like that, kept in abeyance. Now, so far as I'm concerned,
But
I-
whether the term intermeddling with the estate of the deceased
Yeah.
would not bring a person who is filing a probate.
I think follow it.
You see, the term legal representative is defined in section 319 of the code, 3 or 219, says a person who
Succession
looks into the estate of the deceased as well as a person who intermediates with the estate of the deceased.
And here, earlier when the application was filed, subject was held. The court has relying on that 95 judgment saying that can in a suit give on substitution can proceed, but the decree cannot pass unless he gets it.
That is why. But the
If
suit
now
can proceed.
difficulty found, he is not taking any steps for the disposal of the probate for last 10 years pending like that. And we are deprived of our right.
No, but therefore the question is out there, why has there been no challenge to that order of keeping it in suspension, the probate proceeding, the application for substitution? Then you have somebody to fight because the proceedings cannot abate because it is filed within the time.
He is fine based on that his pendency of the application.
Because in the other case, that is why I remember,
Right.
that particular application is filed by somebody for the purpose of I think, for saying that the rejection of the plaint. And that rejection of the plaint was rejected for which a CRP was filed.
Maybe it's
Now, in that CRP, this person, Hemendra Prasad Barua, was made a party. Because at that point of time when the suit was filed,
Right.
so the matter was pending. So one fine day it came up before me. So I asked him, whatever may be, tell me, can this proceed when this person is long dead and you have not substituted anybody? So it has abated. So the abatement happened. So then the matter has gone. So the
matter in
order by which has already abated.
was filed.
One Mr. DJ Das, you have a counsel, no?
Yes.
He has
That I know, but that was the time.
Please have it. File by.
Somebody filed an application and against that it
And
was.
against that,
So there it is.
even
Anyways,
not in this.
now what do you want? So your
Yes.
injunction proceedings is pending.
Yes, ma'am.
Then
My
why you
no,
are not
ma'am, when
fighting
we-
it out?
When we filed this application, the learned court below did not say that because of this earlier order whereby the substitute fiction as well as the first kept in abeyance, I am not taking up your application. That is not taking.
Let us see the impugned order.
Well, learned court below says something else. Can you kindly turn to page 159.
159.
I read it.
Ah, your heart.
Since petition number 12 filed by the learned counsel for the prayer to defer the passing of the order during the pause that he may be heard. You can skip a second paragraph. Defendant number 2 filed a petition under order 39 for praying with a prayer to set aside ex parte ad interim injunction order dated 13/8/2012, showing cause of change in circumstances as much as the sole plaintiff died on 31/7/2013, and the deceased legal heirs are not interested in pursuing this as they have not taken any steps to substitute themselves in place of deceased plaintiff. Defendant number 2 contended that ex parte injunction is causing hardship to her, as it has restrained her from enjoying her shares in a publicly listed company belonging to her family, which accounts for 27% of paid up share capital of the defendant number 1 company, for which she has prayed for setting aside the order dated 13/8/2012. Somnath Chatterjee for the plaintiff filed written objection contending that the misconceived and state of the deceased plaintiff devolved upon him as he is the sole executor under the last registered will and testament dated 19/9/2012, for the plaintiff died on 31/7/2013 during the pendency of the December 2012. It is contended that the probate proceeding in respect to the state pending for the Calcutta High Court, being that number 20 converted into was 20. It is also contended that filed an application on 12/8/2013 for substituting name in place of plaintiff, but the state application along with statute number 41 of 12 is kept in abeyance by order dated 20/12/2013. By observing that the state substitution will be heard only after the executor has obtained a probate and produced the probate of the registered will of the deceased. The civil division petition number 27 filed by him and petition number 2 respectively was dismissed by common order dated 14/11/2014 by the Honorable Guwahati High Court. Denying the defendant number 2 allegations, it is contended that such as substitute pending disposal, the question of setting aside the order dated 13/8/2012 is not tenable and thus
So this at page 162, the High Court had, by the order dated remand, had declined to interfere with this court's order, which has kept the substitution petition filed by so and so in abeyance till the disposal of the probate. In view of the matter, and for that reason,
Yes.
substitution is
substitute
kept in
petition number
abeyance.
20 kept in abeyance by the Honorable Guwahati High Court.
And you did not do anything.
Well, it's one.
No, how do I do anything?
Well, what I want to impress upon your lordship, although we filed the order by saying that we want setting aside the order, basically we are not interested in selling the shares. This was the prayer in the injunction before the Chinese. Their prayer in the temporary injunction was that we should not sell the shares. That restraint order do not want to disturb or do not pray for disturbance. Our prayer is that since my name is there in the share and it is lying in the demand account of in the HDFC Bank, I still allowed to enjoy the benefit of a shareholder, participate in the board proceeding, etc. Because status quo went by what wanted modification or clarification of the injunction order. Because injunction order, when there was status quo in respect to the share, status quo went in whatever manner the parties were placed, that continue. So since I was joint shareholder, as a joint shareholder, whatever my position was, that continue. So that kind of clarification basically what we wanted before this time. If some observations
Now
made
tell me, how can this possible?
by before very
Unless something is not done with the 17th
even I was
That's the
that
problem.
order something to be done. But by way of an observation, whether your lordship can give some verification that by status quo order, what the court below has already passed an order. Your lordship makes an observation that yes, by status quo, what was the meaning? I was
Oh
the-
no, Mr. Mutla, you think of a way by which that order dated 17/11/2015 passed by this court can be touched and fixed. If that order can be fixed in some manner,
or
you get it. That is the only way out.
or my lord, we can file a review of that order after so many years. This is causing real hardship to me. I am a joint shareholder and I am not allowed to enjoy the benefits of the shareholder. I have got 27% stake in the shares, in the company shares. And in status quo, order is understood as a stay. Because never met lord, kindly have to look at the prayer made in the temporary injunction. I have annexed it.
Where is that order?
Now, my lord, the application I am doing, my lord, page 32 start, and their prayer is at page 45.
No, where is that order, status quo order?
Yes. It is.
This one, 13/12,
Page 49.
13/8/2012.
My lord, page 40. Page 53, second paragraph is the property part.
Now, thereafter, what order has been passed?
After this temporary,
After this.
so far as temporary matter is concerned, what?
No, thereafter some order has been passed on 4/9. Because you see, Mr. Muzumdar, kindly see one thing very important.
Right.
Kindly come to page 53.
Yes.
The last 4 line. Accordingly, notice be issued calling upon the opposite parties to show cause as to why the ad interim injunction shall not be granted for, and in the meantime.
My lord, parties are there.
So in the meantime has to be therefore limited to 4/9/2012.
It was therefore extended, my lord, my instruction.
Was it extended until further orders? And it have been extended after the date? Because if now they cannot take into action this, they can't proceed in view of the substitution being kept in abeyance.
And also,
Could the extension order have been passed thereafter? Think about that.
Right.
I think that is the way out.
Right.
Because normally you must have most probably appeared.
Right.
This person has died on 13/1/2013 or something.
yes, 13/7.
13/7. So in the meantime, what has happened?
31/7/2013.
31/7.
Right.
So was it therefore, was it only extended till the next date or till the final disposal of the injunction happened? Then that is the only way out. You can tweak with this order.
Or we file an application seeking a review of the order.
Yes, in fact, you see, I'm surprised when that order has been passed. Where is the question of keeping it in suspension? A person is, yes, he intermeddles with the affairs of the state. He will become a legal representative. So under such circumstances, it will be there. So you may accept him as a legal only to that extent till it is finally decided he cannot pass a decree. But what will happen in the meantime?
Yeah.
You can't keep this thing in such abeyance.
And more so, by not taking advantage of this, they are not pursuing their
No,
probation.
that is what they won't do.
Right.
Because thereby you are blocked.
I am
One
blocked.
fine day you don't have a bargaining power for which at the end of the day you have to give up.
Which will fine. Or what is the tip?
No, I'll admit the appeal. the appeal is admitted. At the present state, taking into account the appeal, taking into account the appeal is directed against the rejection of the application under Order 39, Rule 4. Application which have been registered at Ms. J case number 21/2020. And the said proceeding relates to the order dated 13/8/2012, passed in what is this Miss case number?
27 of 2012.
Ms. J case number 27/2012. This court directs the registry to call for the records of Ms. J case number 27/2012 as well as Ms. J case number 21/2020. However, this court had not called for the records of the suit, that is title suit number 41/2012. Issue notice upon the respondent by way of registered post along with usual process, making it returnable by 5th of April 2024. Steps be taken by the appellant by 11th of March, no, by 7th of March. You want to take steps by the stick? The appellant is also given the liberty to take steps upon the respondents by way of the stick, routed through the registry of this court, and file an affidavit of service on or before the next date. Now, tell me one thing. Let us hold that the order is bad. Then I can't touch that order 2012. No, whatever may be. I can't touch. Because before this court, there is no application for modification. It's only in the memo of appeal. Remember that. I hope you don't fall into that trap later on. That is why I asked, where is your eye? Because today I may say, okay, that order is bad. So, what is the consequence? It does not touch that order. At the end of the day, you do not get the benefit. Or do I fix it on next date and you file that? I don't pass this order then. I think that without doing that, you are in serious trouble. So you will have to therefore ask for modification of that order, or whatever application which you have filed, a similar application has to be. I don't pass this order now. Okay, Mr. D. Mojumdar, Senior Counsel, 6 for an accommodation of filing an application in the matter. Is the matter on? You want when? You have to file the application.
Doctor, give us a 2 weeks time.
2nd of March. In the meantime, the appellant would be at liberty to file the application effect. Because without that, you are in trouble. Because On
It will not
5th,
help.
they will come up, oh, we don't have notice.
For orders, item number 4.
What? Yes. What are you doing in a RSA? Yes, tell me.
Arrest of 2003,
That is why.
madam. Respond number 3 has passed away, madam.
Huh.
Some delay has occurred.
The pilot I.
I have filed the IA, my lord. 2032, 2031. There are 3-4 IAs. What happened actually, my lord, the person, he died on 24/11/2012.
Hmm.
We filed a substitution petition, my lord, in 2014, my lord, 28th August 2014. There, my lord, one of the legal heirs was left out. Then
Sure.
my learned friend came and pointed out that there is another daughter, minor daughter, we did not file into her name.
Oh.
So there was a lot of confusion. We IAs were filed. So ultimately, my lord, if all these IAs were withdrawn, the consolidated petitions have been filed. But setting aside abatement, confirmation of delay and submission. So in the process, though there is a delay in these cases of around 1400 days, my lord, but actual delay is
Well,
around
that
1
was
year.
not necessary. If you have already those people, some of the people of the legal representatives are always there. Somebody is not there. How does it make a difference? It's a question of the estate being represented. That is the Supreme Court judgment, where you need to have the estate being represented, so that the person is not unheard. Anyway, now what has happened?
Now there are, my lord, 4 IAs, my lord.
Which are the
2032 is for the condonation of delay in the setting aside of abatement.
203? Then
2033 is for setting aside the abatement.
then
2031 is application for the condonation of delay in substitution. That may not be necessary, my lord, once the abatement is set aside. And then 2034 is substitution.
notice issued.
Notice issue, my learned friend was already appearing.
Then what is there?
He was appearing for the respondent number 3.
1, 2, and
We are concerned with respond number 3
My lord,
only.
only respondent.
So we have to appear for 1, 2, 3, 4. You are appearing.
Yes.
So we substitute it. Unnecessary, because otherwise the respond number 1 and 2 is already there.
It is there.
All these applications are taken
IA number 2034, para 3. In substitution from 2013. Lordship has fixed it in the usual court. Lordship has fixed it in the usual court. Hearing. Well. No. It is the month of April. Right.
Well, the root case here is a civil revision petition in which two IAs have come. The civil revision petition, my lord, was directed against an order by which my application under Order 7 Rule 11, challenging the maintainability of the suit was, my lord, not, my lord, allowed by the trial court. So therefore, it was held to be maintained. Against that, my lord, I'm coming to the IAs actually, my lord. Against that, I came to put it on this proceeding and further proceeding in the suit proceeding. Now, in the suit, my lord, there was an application under Order 39 Rule 1 and 2 by the opposite side. That proceeding, my lord, was not taken up. Initially, there was no adjournment injunction. And in my IA, in my CRP, my lord, the IA was filed by them that construction has to be stopped. The learned court, my lord, stopped the construction, against which, my lord, I have filed a subsequent IA. This is how the two IAs are connected.
We are not concerned. First, whether your IA is maintainable or your CRP is maintainable or not. If we dismiss this, if I allow this, further consequence. If I dismiss it, all other goes. So why should I spend my energy and time onto those IA business?
The IA
Let us
basically has stopped my construction.
forget about that. Now show me what is your ground.
My lord, my ground.
What is the ground? Let's see
just,
the impugned order.
I just lead your lordship to the fact.
No, impugned order.
The impugned order, my lord, is
Why you are asking for dismissal of the suit?
on the ground of limitation.
Huh?
On the ground of limitation.
Limitation. Why?
It was a suit for specific purpose.
Oh.
There was a suit, my lord, initiated by 2017. That suit, my lord, was dismissed. It is understood that we had not appeared at that point of time, and therefore it seemed to be a dismissal under Order 9 Rule 3. Now, they could have thereafter approached for declaration of the, or there is no bar, my lord, for petitioner filing of the suit, subject to the law of limitation. That is what the Order 944 says.
Mm.
Now, 2022 July, they come back after dismissal of the 2015. In 2022 July, they come back and file a subsequent suit. And whereas the deed initially is of 2006.
2000?
2006, the agreement for state was in 2006.
Then
in 2017, the first suit was filed. That got dismissed for non-prosecution in 2016. Then in 2022 July, my lord, the second suit is filed on the same ground, seeking specific performance of the sale deed of 2006. And in the meantime, I am a subsequent person. And my land, what I am trying to say is that there is no relief except sought against the suit, except that I have been made a party saying that they have to show, or there has to be a decree saying that the suit land is different from the land that I have. Now, why I am more aggrieved, my lord, is that now my construction has been stayed, my lord, which is a different parcel of land altogether.
So that who is it?
This honorable court
How?
under 151, right?
How?
Under
How?
150.
How can you ask for stay of here? There's a stay of the approved proceeding.
Yes.
Therefore, you have approached this court.
Yes. Fine.
Hmm? For me, there is no admission hearing stage, no motion stage. Every day is a finishing stage. So this type of matters should not remain. Now, you see, recently a judgment has come from the Supreme Court. The question of limitation cannot be decided. That's the recent decision. Earlier there were 2-3 judgments which were there,
Say that, my lord,
which permitted. But this very recent judgment has come that you cannot do it. We'll take it up at 2. Get me that judgment. Both of you, get me that judgment. Recent Supreme Court judgment says you cannot. Although there are earlier 2 judgments which permits that Order 7 Rule 11 can be taken up in respect to this point of limitation. Because that is a case of whether, but in that case, it can only be taken not on the basis of you, what you say. If on a perusal of the plaint, it is seen that the suit is barred by limitation, you have to show before this court not on what you want to say about 2002 6 suit or something. You are to therefore show that from that agreement, the period was completed within 3 years. It is there. And that period having been completed as per the involvement made in the plaint, so it is barred. Then only you have a case. Otherwise, not on the ground that, oh, this is 2006 agreement, so 2022.
2006, there was a suit pending, and probably that is why their transaction could not. That suit got disposed in 2015. So when they filed a suit in 2017, my lord, the question of limitation did not come. But then when the suit got dismissed in 2018, under Order 9 Rule 3, my lord, then Rule 4 has to apply, and then limitation, my lord, has to be seen and examined again from that perspective.
No, whether that is apparent from the plaint.
Yes. There are categorical aberrations.
Let us see the plaint.
Page 15, Annex 1. Refers page 21, penal page 7.
So your only case is that the suit was filed in 2007, 17. And after 2017, the suit was dismissed when?
2018,
2018.
4/4/2018.
This was at the stage of Order 9, Rule 2.
Rule 3. None of the parties have appeared.
None of the parties have appeared. So you did not appear.
My lord, the notice was yet to be completed.
So the fresh suit could be filed.
Fresh suit could be filed.
So your basic case is the fresh suit has to be filed within the period of limitation from the date on which the earlier suit was.
I would say, my lord, based on which they say that the cause of action had accrued. Cause of action for
earlier-
the earlier suit had accrued in 2015, according to their own statement.
So as per them, the cause of action has arisen. They came to know in respect to the 2017 suit. And from there, the cause of action for seeking a specific performance started from then.
Cause of action for filing a subsequent, my lord, also has to be related to the original cause of action. Order 9 Rule 4 does not say that after dismissal, my lord, that you can, there's a fresh set of limitation from the
No,
date of
you cannot. You don't.
It
Your
has to
fresh-
relate back to the original date of cause of action.
So original cause of action, when it arose in the earlier suit,
It
he
will
may
remain the
not
same. It
be
will not be
precluded.
disturbed. It will not be disturbed.
He would not be precluded from not filing. But if he files a fresh suit, then for limitation, it has to be counted from then. A limitation cannot thereupon accrue because as per Article 54, there are 2 points of limitation. The first is the date which is being given, or on the date on which the plaintiff comes to learn that there has been a denial. So here the second aspect will come in, because it is a very cleverly drafted plaint where no dates have been mentioned.
Right.
But
in fact, I placed this judgment before the trial court, saying that this kind of clever drafting, my lord, cannot help them escape the rigors of the limitation.
yes, but we have to say you cannot have that. If your period of limitation as per the earliest was sometime in 2015 or 16 or even 17, you have to file the suit within, unless you can, whether an application could have been filed for restoration.
My lord, that aspect, my lord, is different. Restoration, my lord, probably would run, the limitation would run from the date when I say that I had the knowledge of.
So wouldn't that suit be restored under Order 9 Rule 4?
Then it would be restored under Order 9.
So then he gets the limitation in that suit.
My lord. Because the original suit of 2017 is now restored back.
Huh? Why? After hearing so much? The day after tomorrow, yes, after 2, at 2, or at 3. No, the question therefore is, you may have a right for restoring that earlier suit and thereby get back the period of limitation from there. But can you have the period of limitation here? Very difficult. Understood. But then also you can restore it. You can file. But if you are filing a fresh suit, the problem which has arisen out here is this. If you file a fresh suit, there are 2 points for Article 54 to apply. Article 54 says first, on the date on which it was required to be done, 3 years from there. There is no date, then the date on which the plaintiff finds that he has been refused. So when the same suit has been filed in 2017, stating a particular date on which you have felt it, that it has been refused. So that date, from that date, it will be 3 years. Sale deed is consequential, but No, Mr. Sharma, that is beside the point. The sale deed will only come when you have a right for specific performance. So we are not on the question of res judicata. Kindly don't bear in mind. We are not on the question. We are on the question of specific limitation. So here it will be a case you can, I don't know whether you can still file an application for restoring that suit, which you can do under Order 9 Rule 4, and thereby get back your limitation from there. But here, for this purpose, the limitation has ended because you have earlier said that the limitation accrued on the date on which you filed that the defendant number 1 to 6 has refused. So then it is on the face of it, on the plain, one can decide, yes, the suit is barred by limitation. Then why did you file the earlier suit? Specific performance. When there is no date, therefore, unless you have the right of specific performance, do you have any right over the land? No. The only right which flows upon you is from the right of specific performance. So here the specific performance right extinguishes within 3 years from the date of their refusal, and from the date of the refusal for which you have already filed a suit earlier. I'm not on that. Sale has been done. That is a challenging a sale is subject to you having a right of specific performance. No, Mr. Counsel, kindly see, where is your earlier plaint? Where is your earlier plaint?
Page 61.
Page 61. Kindly come to paragraph number 13, page 64.
He objected to our mutation also to the sale purpose. That's what it is.
Kindly see, that it may be noted that the defendants have made an agreement to sell other parts of the scheduled patta and the dark for which she needs sale permission and has been ordered by the competent authority so far. Under such circumstances, the plaintiff has been compelled to seek for specific performance of the contract for sale. That a cause of action for the suit arose on so-and-so when the agreement was executed and registered on so-and-so to Iman when the civil litigation pending on year when the litigation ended and many other dates precedent and subsequent thereto within the jurisdiction of this court. So under such circumstances, your right of cause of action arose on the date when you filed the suit at best. So if your right to cause of action, because you are asking for specific performance, if you have asked for specific performance, if it is dismissed for default, you may have a right to restore. That is another aspect of the matter. We are not on that. You may even ask for amendment of the plaint of that if you restore and ask for all the subsequent events which has happened. But if you file it after 7 years, maybe wrongfully because of your lawyer not informing it, but the limitation does not stop. Once it runs, it runs. So we have to say on the date of filing of that suit, your limitation has started at best. And then also it is 3 years. So we come at 2 o'clock.
and do some. That, my lord, the scope of order 7 route 11 has been otherwise been discussed. And also
there-
it was
there-
the second principle that was discussed, that the rejection cannot be a part. One part cannot be rejected and one part cannot be allowed. And that is generally on the scope, my lord, order 7
there is another
rule 11. But this one I could not get a printout, my lord, because my SSD online is, I got somehow not working. Prior to that, in 2023, the online, this one I had referred to in the prior. This was a case where, my lord, on a point of limitation of only application under order 7 rule 11 was allowed. By saying that by clever drafting, you cannot change the effect to overcome the law of limitation. Otherwise, what Gita basically says is that the principles are correct, that only the plaint is to be considered. If on basic and clear reading of the plaint is evident that there is no cause of action, the cause of action is only then the penalty can be made. Otherwise, cannot be general power to be exercising.
Yes, is that Madina Begum versus Shiv Murthy Prasad Pandey. This is the judgment. The 54 has been dealt with. This one, Pateji and Company, 2015 8 SCC 390. This was a case of Article 54. Here it says, we have considered the rival submission. The specific performance is claimed of a written agreement of sale dated so and so. And as per the terms, the performance of the contract was fixed till 2/12/1973. The defendant, by subsequent letters dated so and so, sought for extension of time to enable them to obtain permission of the lesser, and the last extension of the 6 months expired on 1/2/1977. In view of Order 7, Rule 11A and 11D, the court has to satisfy that the plaint discloses a cause of action and does not appear to be barred by any law. Article 54 of the Limitation Act stipulates that the limitation for filing of a suit for specific performance of a contract is 3 years from the date fixed for performance, and if no date is fixed, when the plaintiff has noticed that the performance is refused. The fact that the plaintiff were put in possession of the property agreed to be sold on the date of the agreement itself would not make any difference with regard to the limitation of filing the suit for specific performance. In fact, both the courts below have rightly held that Article 54 of the limitation does not make any difference between a case where possession of the property has been delivered in part performance of the agreement or not. In the same way, the courts below have also concurrently held that even if any permission is to be obtained prior to the performance completion of the contract, the mere fact that the defendant have not obtained the said permission would not lead to inference that no cause of action for filing of the suit would arise. Further, it is not the case for postponing of the performance to a future date without fixing any further. The last extension of yet another circumstances was pointed out to prove the laches on the part of the plaintiff. They have considered the High Court committed manifest error in reversing the well-considered order of the trial or rejecting the plaint as barred by law of limitation and impugned judgment in liable. I think this judgment applies to you.
In fact, Ramisetti Venkataraman also applied, and Article 54 has been recently discussed in my lord Sapir versus Sandhuba, 2023 at Yon Act 1292. But I'm just we find in Order 9 Rule 4 is that it is in two distinct parts. First part, when you file the subsequent, it clearly mentioned that the law of limitation. And there is a colon and the remedy of restoration also. In Sapir, my lord, para 12.
Which one?
Article 54 as a discussed.
23, 2005-1 or 191-292.
1 to 9. 1 to 9. Sapir versus para 12. Bottom side, my lord of para 12. Limitation for fighting of the other judgments are also. Ravi Sethi, my lord, para 28.
Yes, but you have. Understood. But the fact that in 2017 you have filed a suit makes it clear that you construed it at that point of time that you have been refused. Otherwise, you would not. Yes. No, but the filing of the suit, this is okay. But the filing of the suit, there are 2 points of limitation. 2 points. One is when the date is fixed, which is not mentioned anywhere. That is, so we come to the second one. The second, when the plaintiff has knowledge about the refusal. So your knowledge of the refusal comes on the date of filing of the suit at best, or maybe prior to that. Then why did you file the suit early? Why did you ask for specific performance? Obviously, so therefore you knew it at that point of time. So you knew that they were not complying with that, and that is why you filed the suit. Oh no, I think there's no facts. One fact, you see, I'm not going to look into any other document, only your plaint. Your plaint categorically mentions that there was a suit filed in the year 2017 seeking specific performance of that agreement. That is enough for me. Okay. Whatever it may be, you may restore it today. Tomorrow you file an application for restoration. That is a different thing. But the fact that it was dismissed for default or not, that is immaterial. But the fact that you knew at the time of filing that suit that you have been refused. So under such circumstances where there is no date fixed, from there it will be 3 years. And we may construe the filing of the suit as the date on which it has been reviewed, then also 3 years is elapsed because you filed the suit in 2020. So the instant application under Article this is for preliminary. We are not on preliminary issue. We are for rejection of the claim. Anyway, okay. Anything else? You have to now go to Supreme Court. Yes. This is an application under Article 227 of the Constitution. We construe it as 115. This is not 227. It will be 100. This is an application under 115 of the Code of Civil Procedure, seeking revision of the order dated 10/8/2023, passed by the learned civil judge, senior division, Kamrup, Amingaon, hereinafter for short, referred to as the trial court in Mizze case number 34/2023, in title suit number 116/2022, wherein the application filed by the petitioner under Order 7, Rule 11D, read with Section 151, was rejected. For deciding the said dispute, for deciding as regards the legality and validity of the said order impugned in the instant proceedings, this court finds it relevant to take note of that the instant proceedings relates to rejection of the plaint. Considering considering the scope, this court would therefore limit itself as to whether, from a perusal of the plaint, it discloses that the same is barred by any provisions of law. A perusal of the plaint reveals a perusal of the plaint in title suit number 116 or 16?
106.
116. Perusal of the plaint in
Page 15. Connector 1, 116 of 20.
title suit number
116 of 2020.
116 of 2022 reveal that the respondent herein had entered into an agreement with one Subut Chandra Kolita, since deceased, who was the husband of the respondent numbers, who was the husband of the defendant number 1 in the said suit, and the father of the defendant numbers 2 to 6. The said agreement was entered into on by the registered deed of agreement bearing deed number 4972/06 on 22/5/2006 for sale of 2 kathas of land covered by dag number 934 of KP Patta number 410 for a consideration of rupees 7 lakh, out of which rupees 1 lakh was paid as advance by the plaintiff, by the respondent herein to the father of to the predecessor in interest of the defendant numbers 1 to 6. During the lifetime of late Subut Chandra Kolita, it has been alleged in the plaint that a further amount of rupees 1 lakh was paid by the check on 14/11/2007, and another additional amount of rupees 50,000 was paid in cash. Under such circumstances, it was the case of the plaintiff that only rupees 4,50,000 remained to be paid by the plaintiff at the time of registration of the sale deed. Unfortunately, late the said Subut Chandra Kolita expired on 22/6/2009. A perusal of the plaint reveals that The plaintiff thereupon approached the defendant numbers 1 to 6 to execute the deed of sale. But the defendant number 1 expressed that there was some civil litigation pending regarding the land, including the suit land, from the lifetime of late Subodh Chandra Kolita, and they would execute the registered sale deed as soon as the litigation ended. The plaintiff thereupon made inquiry and could find out that title suit number 227/2001 was instituted by late Subodh Chandra Kolita against one Sri Akhil Kolita and others, which was decreed in favor of the legal heirs of late Subodh Chandra Kolita, and the matter was finally compromised in appeal in favor of the defendant numbers 1 to 6. No date whatsoever was mentioned in the plaint. Be that as it may, it has also been mentioned in paragraph number 6(9) of the plaint that the plaintiff again approached the defendant number 1 to 6 for execution of the registered sale deed in respect to the suit land by accepting the balance amount of the sale consideration. However, it was alleged that the defendants, without executing the registered sale deed in favor of the plaintiff, tried to sell the entire land covered by DAG number 934 and 1053, including the suit land, to some other persons and prayed for sale permission from the Deputy Commissioner Kamrup at Amingaon. Under such circumstances, the plaintiff had filed an application before the Deputy Commissioner Kamrup at Amingaon with a prayer not to allow the defendant number 1 to 6 to sell the suit land in respect to which late Subodh Kolita entered into the agreement with the plaintiff. The said application was registered as KRM 36/15 in the office of the Deputy Commissioner Kamrup at Amingaon. It is, however, relevant to take note of that there is no date mentioned as to when the plaintiff approached the defendant number 1 to 6 or when the application was filed, although the number of the application was duly given. It has also been mentioned that the learned additional Deputy Commissioner, after consideration of the matter, had by order dated 17/8/2016 allowed the defendant number 1 to 6 to sell only 3 kathas 12 lectures of the land covered by DAG number 934, which excludes the suit land measuring 2 kathas covered by DAG number 234, and the additional Deputy Commissioner had clearly mentioned in his order that 934 had clearly mentioned in his order that as of now there will be no bar as seeking NOC for 2 kathas under DAG number 934 of KP Patta number 410. It was also mentioned in the plaint that the boundary of that 2 kathas of land was also specifically mentioned in the said order. Further to that, and as of now, there will be bar on seeking NOC. It was also mentioned that the additional Deputy Commissioner, by his said order, granted permission of sale for 3 kathas, 12 lectures of land covered by DAG number 934, whereas after exclusion of 2 kathas of the agreement land of the plaintiff from the existing 4 kathas, 12 lectures of land in DAG number 934, as stated, the 934. It was mentioned that there remain 2 katha 12 lectures of land only after the said sale to be made in DAG number 934. It was also mentioned that the additional deputy commissioner wrongly shown the amount of existing land in DAG number 934 as 1 bigha 12 lectures instead of 4 katha 12 lectures. Full stop. It was further mentioned in paragraph number 10 that in spite of the said order, the defendant number 1 to 6 were again trying to sell their land, including the plaintiff agreement land, and as such, the plaintiff submitted an application before the Circle Officer Polasbury on 2/5/2016 to stop granting of any sale permission, measurement of the land, etc. On the other hand, the defendant number 7 also submitted an application before the Circle Officer Polasbury Revenue Circle for her mutation in respect of 1 bigha 1 katha 12 lectures of land covered by DAG number 1053 bracket 3 kathas and DAG number 934 bracket 3 katha 12 lectures of KP Patta number 410 of village Kokzhar, Moza Soyoni in the district of Kamrup, claiming to have been purchased it from the defendant number 1 to 6. Further to that, it was mentioned in the plaint that the Circle Officer Polasbury Revenue Circle registered a miscase being number 3/2017-18 in respect of application for mutation submitted by the defendant number 7 and the application submitted by the plaintiff to stop granting of permission for sale and measurement of the land, and the Circle Officer, after hearing the party, passed an order on 30/12/2017 by which he allowed mutation of 1 bigha 1 katha 12 lectures of land, that is 3 kathas covered by DAG number 1053 and 3 katha 12 lectures covered by DAG number 934, although in fact, as per the plaintiff, there was only 2 katha 12 lectures of land in DAG number 934 after exclusion of 2 kathas of the agreement land of the plaintiff from DAG number 934. It has also been mentioned that from the said miscase, the plaintiff could also come to learn that the sale of 1 bigha 1 katha 12 lectures of land by the defendant number 1 to 6 to the defendant number 7. I have also stated that from the miscase, the plaintiff could come to learn about the sale of 1 bigha 1 katha 12 lectures of land by the defendant number 1 to 6 to defendant number 7. However, prior to this knowledge, the plaintiff had instituted a title suit number 56/2017 before the court, which was registered on 31/7/2017 against the defendant number 1 to 6 for specific performance of the contract in respect to the agreement dated 22/5/2006, executed in favor of the plaintiff by late Subudh Chandra Kolita, the predecessor in interest of the defendant number 1 to 6. From the further perusal of the plaint, it reveals that the said suit, being title suit number 56/2017, was dismissed for default on 4/4/2018 for not taking steps by the concerned advocate, which the plaintiff did not know, which the plaintiff could know only in the month of January 2022 and obtained certified copy of title suit number 56/2017 and Mizze case number 108/2017. Thereupon, the plaintiff made further verifications, and after getting certain information about the sale of the land to the defendant number 1 to 7, to the defendant number 7 by the defendant numbers 1 to 6, had filed the instant suit seeking specific performance of the agreement dated 22/5/2006. Comma, semicolon. The declaring that the sale deed number 2443/2016 dated 24/10/2016 executed by the defendant number 1 to 6 in favor of the defendant number 7 is not binding on the plaintiff, and it is liable to be corrected or be rectified by excluding the suit land measuring 2 kathas from the area of the land shown to be sold to the sale deed, and for issuance of precept and permanent injunction. On the basis of the state suit which was filed, and upon receiving of the summons, the defendant number 7 had filed an application under Order 7 Rule 11 D of the Code of Civil Procedure 1908 for rejection of the plaint on the ground that a perusal of the plaint discloses that the said suit was barred by limitation. This court have duly taken note of the order which had been passed by the learned trial court, whereby the application under Order 7 Rule 11 was rejected on the grounds and reasons stated therein, and thereupon the instant proceedings have been initiated. The question therefore arises as to whether, from a perusal of the plaint, does it appear that the suit is barred by limitation? The facts enumerated herein above clearly shows that the plaintiff herein had filed title suit number 56/2017 seeking specific performance of the agreement dated 22/5/2006. The plaint herein is not clear as to whether the agreement contained a specific clause, thereby fixing the date of performance or not. Therefore, the question as to whether the suit was barred by limitation in a case of suit for specific performance, this court would have to look into Article 54 of the Limitation Act. Article 54 reads as follows. So, whatever 54 description table From a perusal of the said above quoted provision, it would be seen that in respect to a suit for specific performance of a contract, the period of limitation is 3 years from the date fixed for performance, or if no such date is fixed, when the plaintiff had noticed that the performance is refused. The expression, inverted comma, the date fixed for performance, inverted comma, close, is a crystallized notion. When a date is fixed, it means it is the definite date. There is a definite date fixed for doing a particular act. Therefore, there is no question of finding out the intention from other circumstances. The expression, inverted comma, date is definitely suggestive of a specified date in the calendar. So, in the case of Ahmad Sahib Abdul Mullah versus Bibijan, reported in 2009, 5 SCC 462, the Supreme Court observed at paragraph number 11 and 12 that the inevitable conclusion to the expression, inverted comma, date fixed for performance, inverted comma, is a crystallized notion, which is clear from the fact that the second part, inverted comma, time from which period begins to run, inverted comma, close, refers to a case where no date is fixed. It was observed by the Supreme Court in the said judgment that when a date is fixed, it means there is a definite date fixed for doing a particular act. Even in the second part, the stress is on, inverted comma, when the plaintiff has noticed that the performance is refused, inverted comma, closed. Here again, as per the Supreme Court, there is a definite point of time when the plaintiff notices the refusal. In that sense, both the parts refer to definite dates. Therefore, the Supreme Court in the said judgment opined that there is no question of finding out any intention from other circumstances. Paragraph number 11 and 12 of the said judgment, having relevance to the instant proceedings, is reproduced hereunder. In the instant case, it would be seen from the facts as disclosed in the plaint that the plaintiff had filed a suit for specific performance, which was registered on 31/7/2017. At the least, the date of filing of the suit can be taken as the date on which the plaintiff had notice of the refusal. The said suit, however, was dismissed in turn with Order 9.
There's nothing written in the order, my lord. 50 order 9 rule 3, but then the order itself does not reflect anything. Page 68. Page 68.
Huh?
Page 68 is the order. Plaintiff side is absent without step. In view of the above, the suit is dismissed for the court. But then since we had also not appeared, it is to be deemed to be under order 9 rule 3.
The said suit, however, was dismissed as is admitted in the plaint, was dismissed for default on 4/4/2018 as admitted in the plaint. If the suit was dismissed under Order 9 Rule 2 or Order 9 Rule 3, under Rule 2 and 3 of Order 9, the plaintiff, there is no bar in the plaintiff for the plaintiff to bring a fresh suit. Unlike dismissal of the suit in terms with Order Rule 8 of Order 9, where there is a bar in view of Rule 9 of Order 9 of the CPC. Therefore, filing of the suit, the present suit, that is title suit number 116 of 2022, can be construed that therefore from the filing of the suit, present suit, it can be construed that the suit was dismissed under Rule 2 or 3 of Order 9 of the Code. Be it as it may, the most important aspect of the matter is that when the plaintiff had filed the suit, being title suit number 56 of 2017, seeking specific performance of the agreement dated 22/5/2006, as it's apparent from a perusal of paragraph number 11 of the present plaint, the plaintiff therefore had due notice of the refusal of the defendants. It would also have to take note of that the date of refusal has to be either prior to the filing of title suit number 56 of 2017 and not thereafter. Now, therefore, the question arises as to whether the suit, the present suit, which is being filed seeking specific performance of the agreement dated 22/5/2006, is barred by limitation on the face of the perusal of the plaint. Taking into account that admittedly the suit was filed in the present suit was filed in the year 2022, and the cause of action and the refusal of the plaintiff of the defendants was prior to 31/7/2017, which is apparent from a perusal of the plaint. The instant suit is barred by limitation. Now, the next question therefore arises as to whether the learned trial court was justified in rejecting the application under Order 7, Rule 11D, by the impugned order. At this stage, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Pateji and Company and other versus NLM Nagpal and others reported in 2015 8 SCC 390, and more particularly to paragraph number 5, 6, 7 and 8, which are reproduced hereunder. The above proposition also have been followed by the Supreme Court in the case of Rami Sethi, Venkata Venkatanna and others versus Nasyam, Jamal, Saheb and others reported in 2023 SCC Online SC 521, as well as in the case of Sabir bracket dead through LR versus Anjum since dead through LR reported in 2023 SCC Online SC 1292. The above propositions of law categorically show that if the suit from a perusal of the plaint it discloses that the suit is barred by limitation, the court can exercise the power under Order 7, Rule 11D for rejection of the plaint. At this stage, this court further finds it profitable to refer to the judgment of the Supreme Court in the case of, where is that? Arindam, where is that? Somewhere it's there. Refer to the judgment of the Supreme Court in the case of Arivandam, Arivandam versus TV Satyapal, reported in 1977, 4 SCC 467, wherein the Supreme Court at paragraph number 5 of the said judgment observed that if on a meaningful, not formal, reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, the court should exercise its powers under Order 7, Rule 11, taking care to see that the ground mentioned therein is fulfilled. It was further observed that if clever drafting had created the illusion of a cause of action, it is required to nip it in the bud at the first hearing by examining the parties searching under Order 10 of the CPC. In the present case, as already observed, the suit from a perusal of the plaint was barred by limitation, inasmuch as the same was barred under Section 54 of the Limitation Act of Schedule 1 of the Limitation Act 1963. Consequently, this court therefore interferes with the order dated, impugned order dated, where's that?
10/8/2023, Annexure 11.
10/8/2023.
Annexure 11.
Passed in Ms. case number 34 oblique 2023 arising out of title suit number 116 oblique 2022 and further rejects the plaint in title suit number 116 oblique 2022. Full stop. Accordingly, the instant proceedings therefore stands allowed. Full stop. Before parting with the record, this court, however, next one, finds it relevant to observe that the instant adjudication relates to the decision as regards rejection of the plaint in title suit number 116 oblique 2022 on the ground that a perusal of the plaint discloses that it is barred by limitation. The same, however, the said observations, however, shall not preclude the plaintiff to approach the court for restoration of the suit if otherwise restoration of the suit title suit number 56 oblique 2017 if otherwise permissible under law. Of disposed of in view of the interlocutory application stands closed. All orders passed, interim orders which have been passed, stands vacated. Main case to interim order stands vacated to hole. Interim order is when he stands vacated. I would like in view of the disposal of so and so, the interlocutory application stands closed and all interim orders passed therein stands vacated. So,
This revision is against an order whereby the
Yes.
learned trial court granted interim mediation without following the guidelines of Rajneesh versus Nihal. The operative portion is a page number 30.
you are challenging what order?
The order dated 28/6/2023 passed in mistake case number 23 of 2020. Passed in
28/6/2023.
Yes, ma'am.
What has been given?
The trial court granted the operative portion is a page number 30.
So 50,000.
50,000, 30,000 plus 20,000 as the cost of it.
So-
30,000 per month.
Per month it is not given.
50,000 the operative portion is page number 30.
31.
30. 30, the discussion is there at the last paragraph.
So why are you aggrieved?
I'm aggrieved because, my lord, the amount that has been directly to be paid exceeds my monthly income.
No, you are only asked to pay 30,000 paid pendant light maintenance at the rate of rupees 30,000 only. Only one time. Wage per month.
Till disposal of title.
Understood. Only that. I think you should be happy. Where is the use of the word per month? Is it there?
Per month is not there.
Then he has asked for pendant light maintenance 30,000 and 20,000 as cost of litigation. That's all. In fact, they should come up before the court and say they put it per month. Isn't it?
Reflect that it's a quarter.
What?
Because I am paying 1,500 it's a stay of the firm.
Understood. But this is only 30,000 you are happy to pay. We'll say for the entire litigation, pendant light, 30,000 he is happy to pay. He'll only pay 30,000 and 20,000 as per the law.
Yes.
I think why haven't you asked the court out there to make it correct? 30,000 pendant light. One time. Where is the word per month? You are not engaged. Huh? You are on behalf of the petitioner but not engaged. Then how are you behalf of petitioner? Tomorrow the petitioner may file a case against you for representing misrepresentation. You have not signed. Have you signed the wakalatnama? Then who are you? You are on behalf of the petitioner. For respondent. Okay, you are for the respondent. You have filed a wakalatnama for respondent. No. Then who is your senior? AD Sarkar. Where is he? Hello? Hello? The matter could have been taken up for disposal. However, this court have duly taken note of that only 2 stenographers have been allotted to this court. And there has been 7 disposals already. And it would not be proper on the part of this court and taking into account that those orders have to be typed out and no further stenographers are being allotted by the court, by the registry. This court has to adjourn this matter, to list this matter accordingly. The instant order be brought to the notice of the Registrar General of the court. List the matter up. Oh. Can you guarantee that I'll be given another stenographer?
Yeah.
Can you guarantee that? No. Then Baki order it might. I'm writing. You see, I've already given 7 dictations. 7 judgments have been dictated. I can't take it up. I have only 2 stenographers. How much these people can. Baki pustakote to order for it, send it to the Registrar General.